Miss Cooper, you have a question. Just want to make sure I answer all your questions before we get started. Go ahead, Miss Cooper.
Those phones, the bailiff, my phone that I had all of our conversations from everything, even where he admitted to stuff that he destroyed our property, it's all on the phone. I have it at, Quinton there or whatever the place is right between Reader John and Delmeedy because my phone overheated. So he's trying to pull those, he's trying to get into my phone. And a lot of that is the conversation because everything we did through my storage units was done via text messages. I've only met the man one time and that's when he came to pick up a payment from me when I was at the water period in Elmont. But to get properly.
Okay, so didn't mean to stop, you. Ms. Cooper, I'm not going to honor your request to continue the case. And I'm not also need to make sure that it's noted that you had plenty of time to submit these documents to the court as well as to the defendant. Seeing that you did not, you will not be allowed to use that at this particular hearing. However, depending on what happens in this particular case, you will have the right to appeal the court's decision. Now, the court did receive some documents from you, and that is what you'll be able to use in this particular hearing. Again, it's up to you to prove your case by preponderance of evidence. With that being said, you may proceed with your case against the defendant.
Like I said, I do understand that I owe him through the communication through the text. My check got interrupted, and that's how I got behind in my fees to him. I had 3 units with Mr. Keller, and he would mess with me, and I would go. He said, "Well," I said, "Can I get my stuff? Try to get my stuff at least," and he agreed, and he would go back and forth with, "Well, if you don't get your stuff out by this date, I'm gonna cut the locks off." And I said, "Okay," which I tried to get a lot of this stuff done. It was just me at that time because my son wasn't, he was out of town, and I was trying to get everything out, and he'd say, "Well, did you get everything out?" I said, "No, sir." "Well, if it's not," but I mean, he'd keep extending it, and everything, but he said, "Well, I started cutting the locks off. I'll have to come back tomorrow to get the one off in unit 2. I said, "But sir, you haven't given me notice under chapter."
That's just echo. Go ahead, Miss.
Under chapter 59, you have to do due process with eviction. He never gave me a 72-hour notice. He'd tell me that I had certain amount of time, and I'm sorry, I thought.
Your Honor, I'm gonna object to this because this is not pled in her small claims petition, Your Honor. So we're going astray of the claims that are made. She's only pled a violation under section 59041 of the Texas Property Code.
Yes, but
Give me a second.
Yes.
So, Ms. Cooper, run it by me again, Mr. Bradley, as to what you're objecting to.
She is alleged in her small claims petition that Mr. Keller and Kick Turn Storage violated section 59041 of the Texas Property Code. All of what she's talking about are other provisions that she has not pled. And nonetheless, section 59041 is not a standalone cause of action under law, Your Honor. And so that evidence or that testimony is irrelevant to this proceeding, Your Honor.
Okay. And again, Ms. Cooper, outside of 5901, what is it that you're stating?
He violated, under property codes 59043, the 43 and 44, he didn't give me due process. He didn't give me a 72-hour. He would tell me to have it out by a certain thing, but then he.
Okay, so let's stop there. So, Mr. Bradley, what you're telling me is that a plaintiff cannot present additional statutes at trial. It has to be included in the pleadings. Is that what you're telling me, Mr.
As a basis for recovery, Your Honor, she has to plead her particular cause of action, and she has not pled these. Number one, they're not standalone causes of action, but number two, they have not been pled in her petition, so she cannot pursue recovery under those provisions against the defendant, Your Honor. And nonetheless, so this testimony is irrelevant. In addition, the evidence that we have presented actually controverts what is being said, Your Honor. But I'll save that for when my time
Okay.
my
Gotcha. I just want a clarification on your end. You're telling me that a plaintiff cannot present additional arguments, case laws, and so forth at trial, that it has to be listed in the petition?
what I'm saying is she can make arguments, Your Honor,
Uh-huh.
but causes of action are what are the vehicles by which a plaintiff can recover. And she is trying to allege additional causes of action at this hearing that were not originally pled as a basis for recovery. And that is not permissible under Texas law.
Okay. Okay. Gotcha. Gotcha. All right. And which Texas law are you referencing?
I'm sorry?
In which Texas law are you referencing?
The Texas Rules of Civil Procedure, Your Honor.
What chapter? What chapter?
Okay, I will pull that for you, Your Honor.
Again, I hear you, but tell me exactly where you're stemming this from.
This is, let's see.
Keep in
My
mind that
apologies,
justice
Your Honor.
courts are governed by certain rules. We're not including the rules of evidence in this particular hearing. Just want to make sure that you are aware of that as well. This is justice court, not county and district.
Understand, Your Honor. It is the general pleading rules under Texas Rules of Civil Procedure 79, as well as the governing case law that governs 79 for the Texas Supreme Court. And I do not have the exact case law on that, Your Honor, but I'm happy to present a supplemental brief to you if Your Honor is inclined for me to get that to you.
Okay, all right. So you're referencing chapter 79 of the Rules of Civil Procedure. And Ms. Cooper, you're referencing a property code
Under chapter 59.
under chapter 59. So where did you get this information from?
Texas law.
Okay,
Texas
so
law,
chapter
59
59, which
Texas property code.
of Texas property code,
Yes,
and that's
sir.
what you reference in your petition.
Yes.
All right, overruled. Come on, keep on moving.
Okay. He, I mean, I understand that I did, and I admit I did owe him the money that a couple months that I did because my check got interrupted.
So you're admitting that you owed him money.
A couple months, yes, but I sent him a copy of my social security paper where it stated it was interrupted, and I was trying to get the money to him. And he said, well, and I said, I don't want to keep owing you because it's taking them longer than was needed. So
Do you have this in writing, Ms. Cooper?
yeah, it's in those text messages.
But do you have that where you can provide that to the court at this time?
The social security paper?
No, these statements provided by the defendant.
So that's what.
Okay, I'm not going to allow it then. I'm not going to allow those statements because he's not here. Okay? You don't have to object to that. I'm not going to, proceed on with that. If you had supporting documents, I understand that there are some, things that may come into play with regards to hearsay, which hearsay really doesn't really apply in most cases in justice courts. But seeing that he's not here and you don't have anything to support that, I'm basing it on your sworn statement. So why don't you tell me what you said and not really what he said and how you're taking this in regards to your agreement with him?
I mean, other than me trying to get my stuff, and then, I mean, I don't know what to say because he destroyed everything. He threw away the 3 units, cut the locks off. He didn't give us notice, as in that's what he was going to do.
Okay, so you're alleging he never gave you notice.
He did not, sir. No, sir.
So
Other than giving me a little bit of time, he'd give me a certain deadline to get, a couple of days or something. And
hold on, stop right there. I want to make sure I heard you correct.
I'd asked for, because I didn't want to keep owing him money, building. So I asked him if I could get my stuff out. He'd give me a couple of days, and then I said, look, I'm trying to get it out, and I had gotten some of the stuff out, but when I couldn't get back over there because my car had broke down, through via text messages, he told me he was going to cut the locks off and throw our stuff away, in which he did. My son's grandmother's ashes, everything I had left to my mother. That's not, there's no amount of money or anything sentimentally that he destroyed.
So just want to make sure I heard you correct.
Just
want to make sure I heard you correct. You're saying that he never gave you any notice.
No, sir.
None at all.
other than text messages, when I told him that, about my check getting cut off and he,
So what was included? How did you interpret the text message that he sent you?
with him saying he was gonna destroy my stuff, throw our stuff away, and he said he was getting a rollaway dumpster, and he told me that he had cut the locks off, he was gonna have to come back the next day for the one unit because he couldn't get the lock off because it was a heavy duty lock. He needed to go get a grinder, he said.
Okay.
And and then a couple days after that, so I took it that he had already gotten rid of our stuff, you know? And a couple days after that, he messaged me, "Where did you go get your stuff?" And I was like, "You told me that you was cutting our locks off a couple days ago. I thought you'd already destroyed our stuff." I mean, I didn't know.
Let's start with a time frame, Ms. Cooper. Let's go from the time that you initially, I need for you to tell me a little bit more. Let's start with a timeline from the time that you initially got the agreement to the time that you initially stopped paying and became delinquent to the time that he actually removed your stuff. Give me a timeline. Tell me a story so I can actually,
Oh gosh.
get what you're trying to
I think
relate.
I think it was around August. This is 26 or 25. I think it was August of 24 is when I rented it.
Okay.
Around, I think it was June of 25. Or June or July 25 is when my check got interrupted.
Okay.
So I sent that paper. I went down to the Social Security Board and I got the paper and stuff because I was, I had filed an appeal and everything with them. And so they said it could take for several months, up to several months. So I was trying, because I had no other way of getting any money. So I sent him a copy, a picture of it because like I said, everything was done via text with Mr. Keller. So he said, okay, well, I guess, well, then he said, well, when can you get me the money? I'm like, as soon as they can start, I said, or I get some money, I will let you know.
Okay. When did you realize that they had removed your property from the storage?
When he I can't remember exactly when that text message was.
Just tell me, give me a date.
When he told me that he was going to go get a grinder and cut the locks off, cut that lock off because he said he couldn't get it off of that one.
You filed this case in December. When did they? Was it November,
It was around
October?
We
What?
go for he sent me the messages and they go a while without hearing anything.
I just need to know, when did you realize that your stuff was gone?
It's around I told him probably around it was around September or something.
Okay.
I'm sorry, I'm not really good.
So roughly 3 months after you stopped making the payments, that's when
Yeah.
you realized that. So how did you get notified that your stuff was removed?
I went by there because finally when he asked me, and then I said, well, I thought, and those kinds of episodes went on for several times, about a month or so, back and forth. And I'm like, oh Lord, it was chaotic and it was nerve wracking to me because I didn't know what to do. And then finally one day I said, I said, so what's my?
So from the months of June of 2025 up until September,
I just
had you been to the storage facility anytime?
No.
So you hadn't made any payments and you were not going to the storage.
He had destroyed it, and then
From talking about June, July, August, September.
and out of blue he messaged me.
Okay. All right, let's do this. You have anything else? Okay, Mr. Bradley, you can.
Your Honor, to begin, I would ask that the court take judicial notice of its record. I've provided attached exhibits to the motions for summary judgment. And I also submitted those to the court coordinator earlier this week. I'd direct the court to number one, our answer, first of all, wherein we state that Ms. Cooper is indeed correct. She rented 3 units from Mr. Keller. She pretty soon after renting the units got behind on her rental payments. She had a 5x10 unit and failed to make payments from April through August of 2025. Then on a 10x20 unit, she failed to make.
I'm sorry, Ms. Bradley. One thing I did not state, and there would be no interruptions, as far as rudeness. So while he's talking, I thought I was clear when I said there's not going to be any type of disrespectful comments made while he was quiet while you were talking. He knows the rules of the court, and I'm going to make sure that you respect him while he's talking.
Yes, sir.
Okay? You understand, Ms. Cooper? I'm sorry, Mr. Bradley. Please proceed.
Thank you, Your Honor. As I was saying, she rented a 10 by 20 unit and became delinquent on her rent for May, June, and July of 2025. And then she rented a second 10 by 20 unit and became delinquent on her rent from May, June, July, and August of 2025. The past due rent on these units owed to Mr. Keller is $1,040, Your Honor. And with regard to notice, Mr. Keller, if the court will review the text messages that were attached to the summary judgment, it's Exhibit B1. There are a number of text messages, and I can start by showing you, Your Honor, on March the 19th of 2025, Mr. Keller began notifying Miss Cooper of payments due and instructed her to vacate one of the units. Then it continues on April the 19th of 2025. There's a specific text message that says, "I need payment by Sunday. I will cut locks and start emptying all units on Monday. I just want to let you know, if you need your stuff, you need to get it all out by Sunday." The payments were already becoming delinquent, and there's a number of other text messages involved here too, Your Honor, that provide her notice. On June the 16th of 2025, Mr. Keller specifically states, "You need to move your stuff ASAP. This is your last warning, and it will be thrown out." There was an additional text message on July the 17th, where Mr. Keller notified Ms. Cooper, "You now owe $780. Do you know when you will be getting your check? I can't keep letting you rent without payment. I know you said you'll pay, but you said that the last 3 months. I've given you plenty of time." And then he says on July 24th, "I will have dumpsters on site this weekend to begin cleaning out your units if you don't exit." I've counted based on the text messages, at least 9 notifications that Mr. Keller provided to Ms. Cooper about delinquent late payments and the possibility of the units being emptied out. And Ms. Cooper provided a number of excuses and a number of pleas to extend the rent, but ultimately the rental payments were never made. And Mr. Keller's affidavit, which is attached as Exhibit B to the summary judgment, spells out the late payments and when they were made, and also authenticates those text messages, Your Honor. And so what we have here is we have a renter who is very delinquent in her payments on 3 units, without any justification. And Mr. Keller, for numerous months, dating back to at least March of 2025, notifying Ms. Keller of the delinquent payments and the possibility that the contents of the storage units would be empty. And I would also direct the court to the storage rental agreement, Your Honor, and that is key in this case. Under the storage rental agreement, which is attached as Exhibit A, to the.
What are you objecting to, Ms. Cooper?
I have never, that rental agreement that they filed, I have never seen that rental agreement. I have never signed a rental agreement. Never.
This rental, I'm sorry, Your Honor,
Hold on, okay, hold on. Let me, Mr. Bradley, go ahead.
This rental agreement was attached to the summary judgment, motion for summary judgment. Ms. Cooper has seen it presumably, but nevertheless, she has acted in accordance with the agreement and ratified it by her conduct. So this rental agreement is binding under Texas law on Ms. Cooper. And in this agreement, Your Honor, it states, number 1, that the lessor will hold no liability for any damages that may occur from the items being stored on the property. In addition, for the failure to pay the rent that's required, the lessor, if the lessor does not receive rent for a given month within 30 days of the payment's due date, any property in the unit past that time shall become the property of the lessor being Kick Turn Storage and Dustin Keller. So, Your Honor, under the
This
storage
agreement was
rental agreement.
electronically. This agreement is
sorry?
electronically signed. Is that right?
Yes, Your Honor.
Okay.
And so the parties operated under this agreement, and under the terms of the agreement, there is no liability for Mr. Keller or Kick Turn Storage. In addition, the evidence that we've submitted, Your Honor, shows that Ms. Cooper was given numerous opportunities to cure the delinquent rent and failed to do so over the course of at least 5 months. And finally, after being notified of the contents of the units would be removed so that the units could be rented to other tenants, that's what happened, Your Honor. And so Mr. Keller and Kick Turn Storage would respectfully request that this court render a take nothing judgment as to Ms. Cooper's claims, which, by the way, Your Honor, are which she has provided no evidence in support of. Her claims are wrongful disposal of property, which is not a cause of action in the state of Texas, conversion, negligence, and trespass to chattels. And we've addressed all of those arguments in our motion for summary judgment. All of them fail as a matter of law. Thank you, Your Honor. Your Honor, may I make one more point? I'm sorry to disturb you.
Yes, sir.
I would also point out that Ms. Cooper has provided no evidence in support of any damages in which she has suffered. And so there is no quantifiable damages that have been presented to the court. So though that is an essential element of all of her causes of action that are proper, and the failure to do so requires this court to render a take nothing judgment. I thank you for the time and thank you, Your Honor.
Sir.
Your Honor.
Go ahead, Ms. Cooper.
I thought that I had included a worksheet that showed some of this stuff. That was, I mean, he destroyed, the tools, we had
Ms.
tools,
Cooper.
everything.
Ms. Cooper. The fact that you did not pay your storage unit like you're supposed to and did not respond to numerous messages that were sent to you that the defendant did provide to me, and you also should have received a copy of that as well.
No, see anything from them other than some paperwork that shows where they were countersuing, and it had that lease agreement. Was the only thing that I've received from them, sir.
So you're saying that you didn't receive the final summary judgment?
No, sir. No, sir. And they have my PO box, that's my mailing address, everything. But they, I mean, of course I can't get my pictures because that's what I was trying to do. I've been trying to print them off.
Hold on, give me a second. Do you still reside at 1132 Faulkner Lane?
No, sir.
When did you
I've
when
been
did you
up in there
cease?
since, yeah, December.
Is that the address you had on the petition?
No, sir. My PO box was my mailing and my mailing address.
Your Honor, we sent documents to the PO box and they came back returned to senders. So we enlisted the services of a process server to find the last known address for Ms. Cooper, and the last known address was 1132 Faulkner Lane. So either Ms. Cooper's being evasive with regarding to service, or maybe she changed addresses without notifying us. We don't know.
According to your certificate of service, it was sent certified mail to the 1132 Faulkner Lane, not to the PO box. Why is that?
That's because we originally sent the documents to the PO box, Your Honor, and that came back returned to sender.
I've got that.
But then we got a process server to find her last known address, and that was 1132 Faulkner Lane.
I have the one that they sent to the PO box in the truck. It is, well, the truck out there. But that's the only one I got, and I've had that mailbox for almost 4 years. I can get proof from the mail lady out there in Illinois that I've had it for almost 4 years.
But regardless, Your Honor, it's her burden to prove entitlement to damages and to her claims here, Your Honor, and she's presented no evidence, Your Honor. So that's just a red herring, I would argue.
Based on everything that I've heard today, it's my opinion that you, Ms. Cooper, did not prove your case by preponderance of evidence. This is based on everything that I've heard today. One thing that I have to consider is what was submitted to the court and certified submitted to you, which according to what I have here, you never received the final summary judgment based on what I have in front of me. However, the court did discover in court that you were delinquent and that you were responsible for getting your items out of that storage and that the owner did have the right to remove your items. Therefore, judgment in favor for the defendant, plaintiff take nothing. Court's adjourned.